Yes, start. It now becomes the duty of the court to instruct you as to the law governing this case and what I shall say to you on that subject. You must be governed by. The court presides at the trial of an action for the purpose of, among other things, determine the law in the case and advising the jury as to what the law of the case is, and also passing upon objections to evidence which may be offered in support of the issues joined, and seeing that improper evidence is excluded from the jury's consideration so that they may readily see the issues and apply the evidence that is adduced in support of the issues or to contradict the issues. The jury are the judges of the facts, and with the jury rests the determination of what the facts in issue are. It is peculiarly the province of the jury to determine from the evidence and the nature and logical inference to be drawn from the evidence what the facts involved in the case are, and by their verdict they determine the facts, and with their finding the court has nothing to do except as I have hitherto said, to see that they are properly instructed and only consider proper evidence. If you if the court, in making any ruling during the trial of this case, has said anything from which the jury interferes, that the court has any opinion as to how this case ought to be decided, I now charge you to disregard what the court said in that behalf. I have no recollection said anything of that nature, but out of an abundance or caution now say to you that it is your duty to exercise that independent judgment upon the evidence in the light of these instructions, and by your verdict determine what the facts in issue are. A fact is said to be in issue when it is asserted on one side and denied on the other, and the facts in issue are to be found in the pleadings in the case. There is a common error which calls arguments of counsel to the jury before the close of the evidence. The pleadings of counsel, that is incorrect. Those statements made by counsel to the jury in explanation of the evidence and in behalf of their respective contentions are the arguments of counsel, while the pleadings are the written statements of the parties to the action filed in the action before it is submitted to the jury, and contain the facts which each claims exist in the case. In this action, Sable and his younger brother Thomas are the plaintiffs, and John is the defendant, and the pleadings in this case consist of the petition, the answer thereto, and the amendment to the answer, and the reply to the amendment to the answer. Keeping in mind what I have told you constituted an issue of what, namely, where a fact is asserted on one side and denied on the other, that there is an issue is said to be joined which the jury must determine. I now say at this point that wherever one of the parties admits an averment which the other party makes, the jury may take for the purposes of the action the admission to be true and the fact established, so that what the defendant has admitted in his answer to the petition you may take as true, namely that on the first day of May he sold and assigned to sale brothers at for the agreed consideration set forth in the contract. In evidence here, the 4 or 5 oil leases described in the petition, together with the wells, powerhouses, tanks, rods, tubing, machinery, fixtures, and other personal property located thereon. Full stop.